Well, thanks for being with Morning Live. Now, the Judicial Service Commission yesterday recommended Judge Phillip Coppin, Judge Elizabeth Dorothy Baartman and Judge Petrus Arnolus Koen to be appointed in the 3 vacancies at the Supreme Court of Appeal. Meanwhile, the uMkhonto WeSizwe Party also withdrew their nomination of the party's parliamentary leader, Dr. John Hlophe, from serving as a member of the JSC. And this comes after the Gauteng High Court recently dismissed the MK Party and impeached former Western Cape Judge President Dr. John Hlophe's urgent application to challenge the JSC's decision not to postpone the current interviews of judicial candidates. So to talk to us more about these developments around the JSC, we are joined by Mbekezeli Benjamin, who's a research and advocacy officer at Judges Matter. Mbekezeli, good morning. So it's been quite interesting over the past few weeks leading up to these October sittings of the JSC. What are your views, firstly, on the MK Party's decision to withdraw Dr. John Hlophe from the JSC?
Good morning, Sakina, and good morning to the viewers. Well, we are surprised to see the MK Party withdraw Dr. Hlophe as a member of the Judicial Service Commission. You'll recall that in the last few weeks, in the Western Cape High Court, the MK Party and Dr. Hlophe himself argued very strongly against the removal of Dr. Hlophe as a member. And in fact, the MK Party filed very strong argument in the Western Cape High Court to argue against the DA's application to review and set aside the decision to designate Dr. Hlophe as a member. And so we thought that because they had fought so strongly, they would sort of argue that point until the end, because it is an important point that needs to be clarified by the courts. And so it is for us quite surprising to see them retreat in a way and remove Dr. Hlophe as a member designated on behalf of the MK Party.
And as you say, Mbekezeli, it is an important point all the same, regardless of the MK's withdrawal of Dr. Hlophe from the JSC. So this is obviously something that needs to be addressed one way or another, because there's also the question of the separation of powers. And, there's been concern expressed also about a lot of political battles being drawn into courts and the courts having to decide on matters that perhaps Parliament should be the arbiter of and maybe set the rules for. So your thoughts on how this should be dealt with regardless of the MK Party's latest action?
Well, firstly, we must make it clear, Sakina, that the Judicial Service Commission is properly constituted as we speak, and they can continue with their work over the next 10 days in interviewing candidates and selecting judges for the various courts. So Dr. Hlophe's resignation doesn't affect that part. But on the case that needs now to go to court, it is really not clear whether the case can actually go to court, because one of the key factors that will be considered is what practical effect will a judgment on this issue happen. Yes, the DA is reviewing the Parliament's decision to designate Dr. Hlophe, but now that the resignation has happened, it's not clear whether that will have any practical effect on the outcome. But for my sense of reading the case and the importance of it is that the case can still go ahead because the decision by Parliament still stands. They have taken a legal decision to designate a member of the JSC, and now the courts need to review whether that aligns with the Constitution. And also, I think to clarify, Sakina, there is a scope within which courts can sort of provide guidance and interpretation on the meaning of the Constitution in particular instances. When it comes to decisions by Parliament, such as the one to designate a member of the JSC, the most limited way in which the court can scrutinize it is through the test of rationality. And rationality is so-called the lowest threshold for Parliament to clear. So the courts are not asking whether this was a right or wrong decision, but the court is asking whether Parliament, given its powers and the wide scope that it has in terms of exercising those powers, acted rationally in achieving the outcomes for which the Constitution gave Parliament that power. In other words, all parliaments need to show is that we exercise this power understanding the factors that were at play and the facts that were before us, and this is the decision we came to. And the court can't go beyond sort of interrogating whether this was a right or wrong decision. So I think that part must be clear. And one of the good things that will help in getting a judgment out of this is that we'll have a very clear, much clearer scope on where the courts can interfere in the decisions of Parliament.
Mbekezeli, just getting back to the work of the JSC. So for this round of interviews, more than 50 candidates being interviewed to fill 21 vacancies. Again, how critical is this judicial process for the judicial system overall and, of course, for the Constitution?
It is absolutely critical, Sakina. Earlier in the year, you and I were speaking about the vacancies that are in the different courts and how long people are waiting to get access to justice. In Gauteng alone, it will take you 5 years for you to get a trial date. And that's partly because of a strained judicial capacity. There are a huge number of vacancies. We heard from the secretary of the JSC that there are 12 vacancies. This time around, they'll only be able to fill 6 of those vacancies, and they are desperately needed. The same goes for KwaZulu-Natal, where there are 6 vacancies there. Those judges need to be filled as in yesterday because of the number of the volume of cases that they have. So in all of the courts where there are vacancies and the JSC needs to fill them, they need to be filled as quickly as possible so that the wheels of justice can keep turning. And in fact, some of these vacancies have arisen because of retirement. A lot of them are because of the senior judges have retired. Some of them, like in the Supreme Court of Appeal, some of the judges have been promoted to higher courts. And so those vacancies are from experienced judges. And so the task of the JSC is to make sure that they find experienced lawyers to fill the vacancies, because judicial capacity is unfortunately based on the years of experience that you have as a lawyer or as a judge. And so the JSC needs to be focused on getting those kinds of judges to be the next crop of judges who will come into the courts.
So if we just look at the backlog that currently exists in our judicial system, Mbekezeli, you look at that and you look at the basic tenet of, justice delayed is justice denied. Things happen, memory fades, things get lost the longer you wait on these cases. And when, for any particular reason, someone has to wait 5 years before a matter can be brought before a court, surely that is unacceptable. That cannot be right. So how did we reach this point where this has become acceptable?
Unfortunately, Sakina, this point we didn't get to overnight. It was a process over a number of years. Some of it does relate to just the capacity of the courts and the resourcing of the courts. We know that that is a big problem. Over the last 5 years, there have been gradual cuts to the budget of the judiciary. And so the judges are doing more and more with less and less. And this is why we're seeing some of the delays in the courts. And so it is a recess problem in one aspect. But secondly, we as Judges Matter have been calling for a number of years for the JSC to start taking its role quite seriously as an HR function of the judiciary. Because some of the vacancies that are being filled right now are of people that we knew 10 years ago that they were going to retire. So we didn't need to wait until they retired before we started getting the process of recruiting new people to come in. And so the JSC doesn't really apply its mind properly to how it should capacitate the judiciary properly. We don't really have clear succession plans to ensure that when one group of judges are sort of retiring, we can get a fresh group of judges coming in to fill that capacity gap. I can make an example of the Supreme Court of Appeal. In the last 3 to 5 years, the Supreme Court of Appeal has lost, through retirement and promotions, more than 15 of its judges, which is well over half. And those judges, some of them have been in the judiciary for more than 20 years. We knew, for example, when Deputy Chief Justice Maya, or Chief Justice Maya now, I should rather say, when she was promoted to the Constitutional Court, she had been at the SCA for 20 years. The JSC could have sort of planned ahead in some of those things, in some of those respects, and make sure that there is a pipeline to fill some of those vacancies. And I don't think that the JSC is doing enough of that work. They are not thinking about retirement ages. All judges should retire by the age of 70. All Constitutional Court justices know from the date of their appointment that they will have to retire 12 years later. So it's the numbers are there, but the JSC is not doing the work in actually being strategic in how it fills the vacancies. And this is part of why today we're in the different courts.
And I think that's a very important point that you make there. But just lastly, Mbekezeli, so we have 10 members of parliament who've been nominated by their various political parties to be part of the JSC. And we saw previously concerns being expressed about how people have interacted with candidates during the interview process. How did you assess day one of proceedings yesterday?
Well, yesterday's proceedings were a breath of fresh air. The interviews were tough. The candidates were asked about their judicial track record, their knowledge of the law, their experience, and the judgments that they have written. So that was the focus of the interviews. And one of the wonderful things that we saw was that almost all the different constituencies in the JSC got an opportunity to ask questions of the candidates. There were a number of new faces on the JSC who were sitting for the first time, and they were given a fair platform to ask difficult questions, whether they were members of parliament or whether they were the lawyers and judges who sit on the JSC. So for us, that was really the kind of JSC that we expect and the kind of JSC that we've been calling for a number of years. And we hope that going forward, the JSC will focus on asking questions about people's knowledge of the law. We are saying the interviews must be tough, and that's because people are being appointed to very serious positions. And in those interviews, though, the dignity and respect that is given to the candidates must be at the center. And that is something that we saw yesterday. So the JSC did a really good job.
Mbekezeli, we'll leave it there for this morning. Thank you so much for your time, as always. Mbekezeli Benjamin is a Research and Advocacy Officer at Judges Matter, talking to us about the Judicial Service interviews that started yesterday and will continue until the 16th of this month, and some of the other matters around that.